looks like Mr. Azultine, I may be pronouncing that wrong, is had a fairly recent warrant. I would, if we're comfortable addressing that on the record.
Yep, Mr. Azultine, are you able to turn on your microphone?
Can you hear me now?
Yes, sir. Okay, it looks like you missed your hearing on July 16th, just a few days ago.
I am, without recourse, sui juris, in propria persona, the living man, and not representing the incorporated Ty Warren Azultine entity. I am the affiant of the affidavit of truth filed in this case, April 26th, appearing specially and not generally under threat, duress, and coercion to correct the mistaken identity misnomer of the defendant, and notice this court to dismiss this case sui sponte for failure of joinder, failure to serve the complaint, failure to state a claim upon which relief can be granted, and lack of jurisdiction.
All right, folks, buckle up, because today we are diving headfirst into one of the wildest court sessions you'll ever witness. On one side, we got sovereign citizens, two self-proclaimed living men who seem determined to argue their own reality instead of the law. And on the other side, a judge who is clearly trying to maintain order in the face of complete nonsense. Now, if you think this is going to be your average courtroom drama, think again. From mishearings, bizarre affidavit, and arguments about the very existence of jurisdiction, this video has it all. We'll break down the claims, the contradictions, and the jaw-dropping statements that will make you question if these people are serious or just living in their own universe.
Before I feel comfortable with this court moving forward, has someone entered a plea on behalf of the defendant?
All right, I'm not going to be able to address this case unless I have assurances that the defendant, Ty Azultine, is the person here, and I'm hearing a lot of nonsense that doesn't address directly, that rather obfuscates the clarity on who you are. If you're not Ty Azultine, then you're a spectator and you're welcome to stay. If you are Ty Azultine, I'll address your warrant, but I will address no other issues in this hearing because this hearing is limited to quashing warrants and setting court dates. So are you Ty Azultine?
Does the caption of this case not say Ty Warren Azultine in all capital letters?
Your Honor, I can speak with Mr. Azultine in a breakout room if you prefer, or...
Well, he's not represented by counsel and hasn't been throughout this case.
I see that he's refused counsel.
Yep. Now, if you're Ty Azultine, just tell me that. If you're not, then I'm going to let you spectate for the rest of the court calendar until we're done.
I am the affiant of the affidavit of truth. And if you look at the affidavit, it will clarify who it is that I am. There are two.
Now let's pause for a second and unpack what just happened. Mr. Otten is throwing out every buzzword and pseudo-legal phrase in the book. Sui juris, living man, affidavit of truth. Essentially, he's saying, I exist, but the court doesn't have power over me. But here's the thing. Courts don't operate on how poetic or philosophical your claim sounds. Jurisdiction is simple. Time, place, and person. And if you fail to show up, guess what? Your case doesn't magically disappear. The judge is calmly trying to explain this, but this is exactly the moment where reality collides with fantasy. And as we'll see, refusing to just say your own name has consequences.
Okay. All right. I've muted your microphone. It appears to me that you don't claim to be Ty Azultine, so I'm going to strike Ty Azultine's hearing, and the matter will be, the warrant will be left outstanding. And Heidi, no one is eligible to appear on Zoom in this case. They have to apply in person for a warrant quash. All right. And sir, you're free to remain and watch the rest of the calendar. We're going to go on to other people who are here.
Calling case number 24, RO04189. This is people of the City of Royal Oak versus Anthony Winston Mathis. Mr. Mathis, are you available?
Yep.
Good morning.
Grand Rising.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of the trust.
This is peak courtroom patience from the judge. He's literally giving Mr. Otten a simple choice: confirm who you are or step aside. Instead, Otten doubles down with more convoluted declarations. And what's the outcome? The judge has no choice but to strike the hearing and leave the warrant outstanding. This is a perfect example of how overcomplicating legal procedures doesn't help. You can have all the affidavits in the world, but if you ignore the court's instructions, the consequences hit hard. And honestly, watching someone try to argue themselves...
Mr. Mathis, today's the date and time for your informal hearing. The citation before the court, Mr. Mathis, indicates that on May the 24th of this year at approximately 9 p.m., you are operating a 2024 Ford Edge, black in color, on 11 Mile Road, near Washington, in the city of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mr. Mathis, you have three options, and three options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this matter. The court will attach the scheduled fine and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances, or you have every right to deny responsibility, and the court will swear the parties and will take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by law.
No, I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William Urick, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility, and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very well. Officer Moran and Mr. Mathis, please raise your right hands.
I do have a question.
Here we go again. Enter Anthony Mathis, another self-proclaimed living man who clearly studied the Sovereign Citizen Handbook. The minute he steps in, he's acting in multiple capacities. Himself, trustee of the trust, special appearances. It's a lot to unpack. And the judge, already ready to navigate through it. Knowing exactly how absurd the conversation is about to get, you can already feel the tension. The courtroom has its procedures, and Mathis is testing every boundary. But unlike criminal cases with actual harm or injury, this is a civil traffic infraction. And that's where the disconnect starts. The clash between pseudo-legal theories and the real-world law is about to get even more intense.
Do you solemnly swear the testimony you shall give before this court shall be the truth, so help you God?
I do.
Thank you very much. Please proceed.
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge, black in color, with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
Very well. And with respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, Magistrate, at that time.
That's based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it, Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
So I have a question. Are you a judge?
Mr. Mathis, the court has already indicated It is a sworn judicial officer. It is exercising its jurisdiction lawfully over you. So questioning the court's authority.
You don't have any jurisdiction over me. I would argue you don't have any jurisdiction. Okay.
Mr. Mathis, the officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please bring the city of Royal Oak. Where's the city of Royal Oak?
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically, or are you asking where it is in terms of who's present on behalf of the city of Royal Oak?
Where is the city of Royal Oak?
This is peak sovereign citizen logic meeting real world law. Matthews refuses to enter a plea, claiming he only answers to a higher power. Meanwhile, the judge is holding the line, calmly explaining that you must respond to civil infractions. The humor here is undeniable. Matthews is trying to make a philosophical argument, but traffic law doesn't care about theology. This is a textbook example of why courts are procedures. They exist to prevent exactly this kind of chaos. And for the audience, this is gold. Watching someone genuinely believe they can negotiate with the universe instead of a sworn judicial officer is both entertaining and an important lesson in respecting the legal process.
Please bring the
Court doesn't understand your question. Are you asking where it is on a map, or where is the officer?
No, I know exactly where it is on the geographic location, but where are they right now?
The officer is representing the city of Royal Oak as a sworn and certified Michigan peace officer. So what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay. Well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written
Well,
under the motor vehicle code of the city of Royal Oak as it is adopted.
As I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Mr. Mathis, is there anything else you wish the court to know?
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward. As far as the injured party, no one was injured. You guys.
Mr. Mathis, I will ask you one more time. The officer is representing the city of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge me?
This is a civil case under the motor vehicle code as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court to know?
Now hold on to your seats, because here comes a classic sovereign citizen maneuver, demanding an injured party in a traffic violation. Matthews keeps insisting that the case should be dismissed if no one was physically harmed. The judge patiently explains, this isn't a criminal case. It's a civil matter under the motor vehicle code. The preponderance of evidence is the standard, not physical injury. Watching someone argue that red light running requires an injured person is both absurd and fascinating. This is a perfect teaching moment. Understanding civil versus criminal law can save you from the embarrassment of thinking pseudo-legal arguments will overturn established law. This moment really highlights the collision of theory and reality. Matthews and his arguments are built on ideas he picked up online, but the courtroom is a reality check. The judge has repeatedly clarified the rules, the evidence, and the limits of civil proceedings. And yet, here we are, watching someone insist on irrelevant offenses while their case proceeds exactly as the law dictates. For viewers, this is both a lesson and a spectacle. Understanding legal basics matters, and ignoring them can turn a simple traffic ticket into a surreal courtroom circus. You almost can't make this stuff up. It's why courtroom commentary is so addictive.
No rebuttal testimony.
Thank you so much. Mr. Mathis, the burden of proof in a civil case is a mere preponderance of the evidence. The officer, a duly sworn and certified Michigan peace officer representing the city of Royal Oak, which is one of two cities upon which this court has jurisdiction, has put his testimony forward. There is nothing in the record that has rebutted any of it. Therefore, the court is finding you responsible for the citation as it was written. The fine for that serves $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into the 44th District Court. Please don't interrupt the court, sir. You may walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 7 days, Mr. Mathis. If you take exception to the court's ruling, you may post a bond in the amount of $175 within 7 days, and the matter will be placed upon the formal hearing docket of the chief judge of the district, and at that time, the city of Royal Oak would be represented by a city prosecutor. So either a bond or a fine of $175 payable within 7 days. That completes your hearing.
So let's wrap this up. Today we saw two sovereign citizens attempt to argue their way out of reality, from missed hearings to demands for injured parties in a civil traffic matter. The judge maintained professionalism throughout, clearly explaining jurisdiction, legal standards, and the limitations of pseudo-legal arguments. The takeaways? First, following courtroom procedures matters. Ignoring them has real consequences, as seen with the outstanding warrants. Second, understanding the difference between civil and criminal law can save you from embarrassing legal mistakes.